Trusting verbal assurances by the opponent is a recipe for disaster in any litigation dispute, and especially more so in matrimonial disputes. What do I mean? To illustrate, recently this whole saga came up. We've been fighting custody visitation rights for the father for the minor child against the wife. We also filed our civil and criminal cases. All of these cases were going on since the past couple of years. Both parties were very tough on each other. We've not been able to come to any resolution till now. However, recently during compromise discussions, it transpired that the client came up with this apprehension that the wife is planning to take the child outside the country. And once this happens, it becomes very difficult for us to get any sort of visitation rights, especially. And so now the client's wife and her lawyer keep giving us oral assurances. Obviously, we are not taking the child out of the country. The child will be here in the country for you to have access. But the problem is, if we believe these oral assurances and then the wife takes the child out, how do I enforce any visitation order that I get anyways? So what we did was we moved an application before the family court where the matter was pending that the child should not be taken outside the jurisdiction of India without the permission of the court. There, the wife's lawyer again comes and says, obviously, we are not planning to take the child out of the country. They give their undertaking now before the court, on the basis of which now we are 100% certain if the wife does take the child out, we can get the wife held liable for contempt of court whenever she comes back for, say, visa renewal or NOC for her new passport or whatever else. So now we are 100% certain that our access to the child's well-being, safety, and our relation with the child is intact because of us getting a written confirmation through the court of oral assurances given by the opponent.